Welcome back to the Legal Brief, the show where we crush the various legal myths and misinformation surrounding various areas of the gun world. I'm your host, Adam Kraut, and today we're continuing our trip around the Pacific Northwest and heading on up to Washington to take a look at the ballot initiative being challenged by two pro-gun groups. Stick around, you don't want to miss this one.
TacPack offers some of the highest quality firearms, EDC, and survival gear in a monthly package shipped right to your door. One month could be heavily focused on gun parts, the next on some sweet survival gear. They're always mixing it up and sending out stuff you will actually use.
We are switching up the codes again, guys. TGC Knife will get you a free pocket knife. TGC Tool will get you a free pocket-sized multi-tool. And TGC Grip will get you a free X-Tech AR grip when you use those codes over at TacPack.com.
Last week, we talked about the Oregon Supreme Court decision, which essentially killed a ballot initiative for an assault weapons ban. If you didn't catch that episode, be sure to check it out by clicking here. As you may have guessed, Oregon's not the only state subject to ballot initiatives. Its friendly neighbor to the north, Washington, is as well. I-1639 was introduced by the Seattle-based Alliance for Gun Responsibility, which unsurprisingly has had hefty donations from everybody's favorite anti-gun, former mayor Michael Bloomberg. The initiative is chock full of anti-gun provisions that are being pushed all around the country and has some other things that'll make your head spin. First up, enhanced background checks.
Enhance. Enhance. Enhance.
Just print the damn thing!
The new section would require that anyone being transferred an assault weapon would need to provide proof that they completed a recognized firearms safety training program, which would need to include instruction on firearms safety, firearms and suicide prevention, firearms and children, safe firearms handling, and an overview of federal and state firearms law, including prohibited firearms transfers. It would also require the dealer to wait to transfer the gun until the local chief of police or sheriff where the person resides notifies the dealer in writing that that person is able to possess a firearm. Yeah, it's as ridiculous as it sounds. Even more invasive is the law's proposal that the Department of Licensing conduct yearly checks to ensure individuals who purchase pistols and assault rifles are able to lawfully possess firearms. In other words, Big Brother's going to be checking in on you on a yearly basis. The initiative would also seek to impose a waiting period on the transfer of assault weapons. That's right, Washingtonians would have to wait a full 10 days to take home their rifle, regardless of whether it was a purchase or if it were a transfer, assuming this were implemented. There would also be a safe storage requirement imposed on those who own firearms. Much like the proposal that we saw in Delaware, this one would impose penalties if prohibited persons gained access to firearms that were not securely stored. Of course, those penalties don't apply if the firearm were securely stored. While the language at the end of this section reads, "Nothing in this section mandates how or where a firearm must be stored," it sure seems like a heavy-handed suggestion as to how one should be stored when felonies are a potential punishment. Simply put, the initiative isn't telling you that you have to store a firearm in a particular manner, but if you don't, well, you get the idea. Now, while under federal law it is lawful to purchase a long gun in another state, this initiative contains language which would limit a non-resident's ability to purchase a semi-automatic assault rifle in Washington. And unsurprisingly, restrictions on the transfer of a semi-automatic assault rifle to those under 21 is also provided for. Now, you'll likely think that you know what a semi-automatic assault rifle may be, but the definition is rather surprising. Hell, it surprised me. The initiative defines the term to mean any rifle which utilizes a portion of the energy of firing a cartridge to extract the fired cartridge case and chamber the next round, and which requires a separate pull of the trigger to fire each cartridge. Exceptions include any antique firearms, any firearms that have been made permanently inoperable, or any firearm that's manually operated by bolt, pump, lever, or slide action. So yes, this would include your good old-fashioned Ruger 1022, a popular choice amongst kids and teenagers. Thankfully, this nonsense isn't going unchallenged.
I challenge anybody!
Previously, the initiative had been challenged by the NRA for its deceptive title and summary. However, most recently, the Second Amendment Foundation and Citizens Committee for the Right to Keep and Bear Arms petitioned the Washington Supreme Court to stop the Washington Attorney General from acting on this ballot initiative. You see, Washington law requires that a readable version of the proposal be on the reverse side of the petition. The SAF previously wrote a letter to the Alliance for Gun Responsibility demanding they comply with this provision if they were going to continue to collect signatures. SAF had learned that the text of the proposal was oftentimes too small or unreadable at all. It also didn't contain any strike-throughs or underlines to denote what is currently the law and what is being proposed, what's going to be added or removed. And if you didn't know, underlines typically indicate added text and strike-throughs are for things that are being removed. Perhaps most egregious is that the paid petition gatherers told people they could read this proposal online. Essentially, sign it and you can find out what's in it later.
But we have to pass the bill so that you can find out what is in it.
Time will tell what the Washington Supreme Court does with this. It seems very clear that the petition gatherers were not in compliance with Washington law, and as such, should result in some form of action being taken against the validity of the petitions. I think Alan Gottlieb, the EVP of the Second Amendment Foundation, said it best. Gun control groups constantly insist that gun owners follow the law. Well, anti-gunners have to obey the law as well. That's it for this episode. If you learned anything from this show, make sure you hit that like button and share it around with your friends. Don't forget to get subscribed, and if you enjoyed the video, consider supporting us via the links down in the video description. If you want to get more out of your TGC subscription, be sure to check out the Gun Collective podcast, which happens live on Thursday evenings. And as always, thanks for watching.
The shirts worn in today's video on the Gun Collective have been provided by Patriot Patch. Closed captions have also been brought to you by Patriot Patch Company. Be sure to click the link in the video description to check out all of their great products, including their cleaning mats.